Hi everyone, it's Wayne Jones, the course coordinator. We're looking this week at week 7, intrinsic materials and the text, and once again we're looking at the week corresponding with the chapter in the textbook, and that is Statutory Interpretation by Michelle Sanson. Look, as always, I'm hoping that you're finding this to be a quite interesting read. I guess what I'm finding, this is the first time that we've used the text. It was chosen for us by Professor Colburn, and I think it was quite a good choice. What I'm finding as we work through the text is that the one thing that you probably do need to do is not treat this as a case book. When there is a reference to a case in the text, think about jumping online and having a look at it, and just to get a little bit more of the background than what's contained in the text itself. Now, look, let's just revisit where we've been in the last couple of weeks first and foremost, before we get into the chapter itself. Remember, we're looking at context, and the context being part of what it is that we do when we try to determine what the intention and the purpose of the Parliament is in the legislation. And in the last week and now in this week, we're looking at intrinsic materials. Now, intrinsic, think internal, think the legislation itself without going outside. So we're looking at the intrinsic material. Last week in chapter 6 we looked at the statutory components, and remember that gave us a few hints. Just looking at the layout of the statute, that gave us a few hints as to how we might work out the intent and work out the meaning of words. For example, two big standout things from last week. Remember, sometimes the Act itself defines the words, so you're always on the lookout for a dictionary or something similar, a definition clause, a definition section within the legislation. And of course, also in intrinsic materials, so far as the statutory components as a whole are concerned, sometimes you might even find an objects clause. Remember also we talked about things like having a long title that gave us a hint as to what the meaning of words or phrases might be. Now, just following on from that, and I think quite cleverly, the text says that we need to look at your textbook, I should say, says that we need to look at the text itself. We're going to go right into and delve into the words themselves. So the first comment that I think is well made by the authors is that every word in the text is meant to have a meaning. Now, why so? Why would that be? Why would you need to say that every word needs to have a meaning? Well, remember, the answer is partly because of the separation of powers. The courts, when they look at a piece of legislation, are really duty bound to say, well, Parliament is taken to have known what it was doing when it was passing the legislation, so all of the words need to have some sort of a meaning. Now, the courts haven't always been as kind as that, and you'll see that that's not always so. But that's the starting point. The starting point is that every word that's in the Act is meant to have some sort of a meaning, and there's some authority given for that in your text. The authors talk about the Project Blue Sky case that you've been looking at in detail already. And that ordinarily the meaning that's given to that text is the ordinary meaning. Now, always exceptions to the rule, of course, but the ordinary meaning, giving, and the phrase that you need to read on the tail end of it is, giving consideration to the sense in which it's used. And, of course, as a great example, the textbook says to you, well, what about the word made? Made in the USA. I made my bed. Something is man-made. So every word in isolation has a number of potential meanings, usually. So the ordinary meaning, given consideration to the sense in which it's used in the phrase. And as I said, great example using the word made. The Hummer case that gets a mention in the text I thought was really good. It gave a great example of how here was a word, limousine, and the tax office wanted to collect revenue, and they said, well, generally speaking, we're talking about cars that are luxury cars. And at first blush, you'd say, well, four-wheel drive, really. it's hardly going to fit into the category of limousine. And then you'll see through the processes that the courts employed that they eventually came to the proposition that if it's not defined in the legislation, which it wasn't, then they felt that the judges felt that they could look at the ordinary meaning, particularly when there really wasn't a technical meaning, and so they made their own mind up based on the facts and circumstances which surrounded the case. Now, here's a picture of a limousine from a limousine service in New South Wales. That's used a Hummer. Now, obviously, this is not the military vehicle which was originally built for military purposes, which I guess is the loophole that the importers were trying to get through. But look, anyway, just a great example of the courts having a look at the words themselves, going to the word, and then trying to come up with a meaning, particularly where it didn't have a legal or a technical meaning, and they just used the ordinary meaning. They said, look, most of us know what a limousine is. Now, that leads us on to the fact that, of course, some words do have a legal or a technical meaning. Not mentioned in the textbook, but I think I may have mentioned it to you in the past, that there was a case I'm pretty sure we'll deal with a bit later on when we look at some of the common law rules, where it's the so-called flick knife case, where a knife, offering a knife for sale was said to be a breach of a law in the UK, where the technical meaning was applied by the courts. They said, putting it in the window is really just an offer. It's inviting offers. It's not a sale, therefore the law wasn't breached. Probably a silly example, but what you need to be aware of is that the courts will look at technical or legal meanings, and then again some great examples given, but silly examples too. And I liked in this Palgo Holdings case, I had a special thing about the judgment by Justice Kirby. I could sort of see where he's coming from, and I know I've mentioned this in the notes, but essentially it's still a good illustration of the fact that most of the judges said, look, pawn shop, in fact, pawn shop has a technical or a legal meaning. By long use, we know what pawn shop means. That pawn shop is somewhere where you bail property, which simply means you hand it over into someone else's care. You bail property, personal property, so not real estate, but personal property, as security for a debt. So the person has the right to hang on to it, to detain it, but no ownership passes. Clearly, what had been established in this case, or what the lender was trying to do, was establish something different so that it didn't have to comply with the Pawnbrokers Act, and it said, we want you to give us a chattel mortgage, and oh look, by the way, we'll hang on to the property, but only because we think that's a good way to make sure that it's being properly looked after. I mean, it really did sound quite contrived, and really that's what Justice Kirby said. But look, without going into too much of that case, again, a really good example of the courts saying sometimes words have legal or technical meanings, so we think we need to apply them. Interesting point too. Remember, I think we touched on this previously when we really talked about the fact that the statutes are always speaking. So if you went back to 1991, here's a picture on the slides of legislation from 1991. Excuse me. If the internet was not huge at that time, we could still have an act that was passed at that time that talked in very general terms, and I think the terminology used here is the connotation. The connotation might be about using technology of some sort to commit a crime. The denotation, the literal, the specific object, might have been something as simple as, say, mobile phones. They would have been new and on the scene at that time, but not necessarily mobile phones which connected to the internet, which they do now. The point is that where the law, where the judges can stretch out a law a little bit so that it fits the current meaning of words, say words like technology or communication technology, the connotation version, where judges feel pretty comfortable saying, you know, although there was no internet in 1991, we think that the connotation is that any type of communication device that used electronic means is something that was covered by the Act. So they could stretch it out. So that's what this section in the notes is all about. You give something a current meaning, and judges are usually fairly comfortable trying to stretch things out a little bit, even if it's to include something that wasn't invented when the Act was first passed. Remember, we've talked before about the fact that you don't go back subjectively to think about the parliamentarians who were sitting in Parliament in Queensland in 1991. It's always an objective test. The dictionary meaning, the comments about the dictionary meaning are probably well intentioned, but look, I think you could cut to the chase with the textbook comments and simply say the safest thing that judges can sometimes do. And I love the comment that they just grab the nearest one. They grab the one which is at arm's length. But I think the safest thing to suggest is that it's permissible to have a look at a number of dictionaries. The comment was made that, gee, judges are still referring mainly to English dictionaries, but I don't know that there was any particular rule about that. Judges can generally grab whatever dictionary suits their purpose. The point that a word, once it is defined, is generic, so you could have 100 yellow ducks. That's why I put the slide up. Once you've defined it once, that's what it means throughout the Act. Of course, there are always exceptions to the rule, and the exception would be if a slightly different word is used in the Act, you can probably presume that that was done for a purpose. So there may be good reason to have a closer look at it before you start making assumptions. And I think really I did give you an example in the notes where I thought that if a word is used, something like vehicle, for example, and all of a sudden they start talking about bicycle or motorcycle or something, have a close look, because it's clearly they've changed the word a little bit, and you should be on alert. I think the comments about variants of words is really answered wholly and solely by the section in the Act's Interpretation Act, which makes it pretty clear about parts of speech and grammatical forms. So in an act where a word or a phrase is given a particular meaning, other parts of speech and grammatical forms of the same word have the corresponding meaning. And so they gave you a great example of, if you've got a definition of to use, then you can use that same definition when you're interpreting derivatives of that word, like using or applying for application, etc. So different tenses, same sort of thing. Now, limiting words, solely, primarily, exclusively, only. The big issue here, of course, was how limiting they are. Solely, primarily, exclusively. Essentially, I think what the textbook is saying to you is that don't take that for granted. Something or other. And now the great example in the text was that case, which was I do recall this case doing the rounds, and that was where the university started to sublet shops, and that was all fine until the local council said, well, you know, you're exempt from land tax as long as you're using the land solely for the purpose of a university. The point that's made in the text is that's fine. You'll always be allowed to sneak some minor variation through to that, and they refer you to the Latin maxim, de minimis non curat lex. The law doesn't concern itself with trifles. Hendiadys. Mind you, this is a word that I've only just come to grips with myself, so I don't know how many of you were quite up to date with hendiadys, but very groovy word for meaning words which combine two words together to come up with a new phrase. And I think the one I gave you in the notes was gold and goblet combined to create a new thing, a golden goblet. And the question that the text asks you is, and they refer you to the Victims' Compensation Fund case that I think we looked at in a previous chapter, is whether or not you had to have both. Do you have to have them both? Do the two things together have to be there, or are they separate? So think about that. And have a look at that case because it's not a bad one. This is a one where you had to have both the symptoms and the disability conjunctively for you to get compensation. And the court said, look, it's just too much of a stretch to read "and" for "or". So symptoms and disability, too much of a stretch to pull out the "and" and put in an "or". But look, stranger things have happened. I suspect that as long as you identify that as an issue, that's enough. Again, same sort of end of the paddock, I suppose, when you talk about these temporal expressions. Will and could, usually referring to the future, did and was, past and is present. So that's more or less where you start from. And then have a look at the case, which is referred to in the text in Chapter 7. Good example, where that would simply lead to a silly result. A construction which would deny the owner's claim when it took the former sensible option rather than the latter. So this is a case where a strict interpretation reading of the case in Gemina Gas Networks would have Gemina Gas really sit on its hands and wait for its pipes to collapse before it could potentially make a claim. And I don't know how the courts really justified this one, except that it was clearly a sensible result. But anyway, nevertheless, they moved away from a literal interpretation, where, as I said, the gas company would have to sit on its hands and wait for the pipe to collapse, to say, no, that would be a silly outcome, so we're going to stretch that word a little bit. We're not, even though the intention was that you could only make a claim after something had happened, so you could only make a claim in the future, the court said, no, we're not going to read it that way. It doesn't make sense. Look, then, and there's an extract from the Gemina case, which I just read out before. Have a look at that one. There's not much in that. It's simply making the point that temporal expressions, will, could, did, was, is, give you a good starting point, but like most of the stuff in this statutory interpretation, don't take that for granted. Okay. Then the text takes us through some common words, and I'm going to skim through these a little bit. I do like deemed, though. Just it's a very legal phrase, and I don't know, unless you've done some work in this space before, it'll be new to you to see that something is deemed to happen. So it's a mechanism of statutory fiction. That's how it's described. It's a made-up thing. It's a statutory fiction. But essentially, when you see deemed, if you're prosecuting or if you're defending, you think, beaut, all I've got to prove is this fact, then I don't have to prove anything else. And the examples that were given were, I'll come back. The examples that were given for deemed were the ones that I put in the notes, at least, were drugs misuse type things, where an attempt was deemed to be the same as actually committing the offence. And sometimes having a large amount of drugs is deemed to make you a supplier. So in other words, if the prosecutor can simply show that you had a kilo of some particular drug, you are deemed to be a supplier, and you're going to have to pedal very hard to convince a court that that's not the case. Have regard to used, import, publish. Look, have a look at the notes on those. The only one that really attracts me is the one about the import cases, just because it was so clever. The two of them, both the Queen and Bull and Campbell against the Crown, really pulled that whole thing apart with imports and said, well, what is an import? You've got an import, which is the thing. You can import something. You can be in the process of importing it. You could have not quite finished importing it. I thought it was quite cleverly done. I thought both of these cases were very cleverly done. So have a look at them. I thought they were definitely worth a look. But it just does go to demonstrate that even a word which seems as clear as someone importing something is capable of a number of different meanings. And you'll see, in fact, in relation to the chemist who was, or the former chemist who was now importing furniture, that there was just enough of a crack there. The court said, the court asked the questions: did she import a commercial quantity? Did she believe that the business associates had intended to use it to manufacture a controlled drug? Did you have to have both of those things at the same time to breach the Act? Because she didn't. There is an argument that she did not. There is an argument that could have been made that they did not happen coincidentally. Did she have the requisite intent at the time that the importing took place? So she had this inkling in the background, but when the importing was happening, it would have been extremely difficult for police to prove that she was in on it. Anyway, interesting. Make of those two as you will. I thought they were interesting cases. All right, well, look, that's pretty much me for this week. Enjoy that reading, and I think that certainly have a close look at those importing cases. I do think they're worth a closer look, but just I suppose try and get clear in your mind that where we're at now is we're still looking at intrinsic material, we're still looking at things within the Act itself for this week, but now we've just burrowed down a little bit to look at some of the specific words in the text to see how courts deal with those. Alright, well I hope you enjoy that, and I'll talk to you again next week.